You ever feel like you're up against a wall with some big organization? Well, get this. Today, we're going to break down the story of one guy, just one homeowner, who took on his entire HOA and won. All right, let's get into it. So this whole thing, it really starts and ends with this number, $500. Now, that might not sound like a lot of money, right? But what that $500 represents, well, that's a huge win for individual accountability. So what's the deal with this number? And that is the million-dollar question, isn't it? This isn't just some story about a neighborhood squabble. No, this is basically a step-by-step guide, a playbook, really, on how knowing the rules and having a little persistence can actually force a big organization to play by their own book. Okay, so to really get how this all went down, you gotta meet the key players. And believe me, this is a total David versus Goliath situation. So in one corner, you've got Robert H. Gelinas. He's the homeowner, the petitioner. And in the other corner, the Meadows at Eagle Ridge, his HOA. Yeah, it's literally one guy against the entire organization running his community.
And the whole argument, the entire case, it boils down to something incredibly simple. The HOA had to hold a meeting for all its members in 2019. That was the rule, and they just didn't do it.
So, you might be wondering, how does one little missed meeting turn into a full-blown legal case? Well, let's look at the timeline, because it really tells the story. Okay, so check this out. The whole year of 2019 goes by. No meeting, nothing. Then, in January of 2020, they finally hold what they call the 2019 meeting. You can see the problem, right? So another year passes, and clearly Mr. Gelinas is like, nope, this isn't right. He files a formal petition, and just a few months after that, boom, everybody's in an official hearing. I know what you're thinking. What's the big deal? It's just one meeting. And that's a totally fair question. It sounds like a simple mistake, a scheduling conflict. But here's the kicker. This wasn't just bad planning. This was about breaking the law. So let's actually look at the rule book here, because the rules at the center of this whole thing, they couldn't be more clear. First up, you've got Arizona state law, and it's not fuzzy at all. It doesn't say you should hold a meeting or you should try. Nope. It says a meeting must be held, at least once, each year. We're talking about a calendar year. This is a legal requirement for every single HOA in the state. And this is the crazy part. It wasn't just state law they ignored. They broke their own rules. The HOA's bylaws, the very document they created to run the show, says a meeting shall be held every 12 months. It's like they broke their own contract with their members. So, okay, the rules are black and white. How on earth did the HOA try to defend this? Well, let's just say their story had a few holes in it. This is where their whole defense just kind of crumbled. You had one person from management testifying that, oh, we always hold the meeting in January. That's just how we do it. Okay. But then another witness comes up and says the real reason was that they were worried not enough people would show up in 2019 because of the holidays. So which one is it? Is it standard procedure or special circumstance? You can see how those two stories don't exactly line up. It did not look good. And all of this leads right to the main event. The hearing, the moment of truth. What did the judge decide? Okay, but before we get to the verdict, there's a quick legal thing you gotta know. The judge wasn't looking for proof beyond a reasonable doubt. That's for criminal trials. Here, the standard is called preponderance of the evidence. It sounds fancy, but it just means which story is more likely to be true. That's it. Even if it's just, 51 to 49, the 51% wins. So, with all the testimony and all the conflicting stories on the table, the judge's conclusion was, well, it was incredibly straightforward. And there you have it. The judge just sliced right through all the noise, all the excuses, and landed on the one thing nobody could argue with. It was, in legal terms, undisputed. Both sides admitted it. No meeting happened in the calendar year 2019. And that was that. Pretty much case closed. So the final order was just a total win for the homeowner. Step 1, petition granted. Check. Step 2, the judge ordered the HOA to, actually follow the law and their own bylaws from now on. And step 3, remember that $500 from the beginning? The HOA was ordered to pay Mr. Gelinas back for his filing fee. He got his money back. A complete victory. Okay, so why are we talking about this one little case from Arizona? Because the lessons here, they apply to pretty much anyone living in a community that has a rule book. Here's the most important takeaway. Those HOA bylaws, all those rules and regulations, they aren't just suggestions, they are a binding contract. And what this whole case proves is that there are real, official ways to make sure that contract is honored. It shows that sometimes all it takes is one person who bothered to read the rules, to hold a whole organization accountable, and that benefits the entire community. It really is true. Knowledge is power. And that really leaves us with one final question. For you, do you actually know what the rules are for your community, your apartment building, your neighborhood? And maybe even more important, do you know who's making sure those rules are actually being followed?